Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzelli & Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by DocketWise, an all-in-one immigration forms and case management solution trusted by thousands of immigration lawyers across the U.S. I really like DocketWise. It makes immigration applications easy by allowing the clients to provide information through simple online questionnaires that are shareable by text or email and available in multiple languages. Not only that, DocketWise provides a comprehensive group of case management features, including invoicing and calendaring, secure messaging, task management, and a lot more. You can learn all about DocketWise and receive a 10% discount on your subscription by heading to docketwise.com/immigration-review, so they know we sent you. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. September brings us some good news for non-citizens. This week, a district court judge ordered Governor Abbott to take down his floating wall of circular saws from the Rio Grande River. What a sentence, no? The Fifth Circuit said, though, that it can stay for now, and I guess we'll see what happens when the whole issue gets adjudicated on the merits by the appellate court. Also, congratulations to Catherine Weber, Stephen L. Timma, Scott Bullock, and Christina Murdoch on a win in an exceptionally factually complicated passport litigation for their client. Those are not easy to win. Check out Arthur Price v. Blinken out of the Northern District of Illinois if you're interested. And thanks for the heads up, guys. 6 complicated cases this week, starting out with a banger. First up is USA v. Minter, published by the Second Circuit on September 6, 2023. Big stuff from the Second Circuit this week. The court is on board with the isomer argument. This case arises in the federal sentence enhancement context. Mr. Minter pled guilty to a federal crime, but he has a prior conviction for sale of cocaine under New York Penal Law Section 220.39. If that conviction matches the definition of a serious drug offense, then Mr. Minter's criminal sentence gets enhanced and he spends more time in jail. As much as a 15-year difference in imprisonment is what's at stake, by the way. Can you imagine spending 1 year in prison, by the way? Is it just me who finds all of this wild sometimes? Whether his New York conviction is a serious drug offense under federal law, in turn, requires, just like in the immigration context, that the New York statute of conviction criminalize only substances contained in the Federal Controlled Substance Act, or CSA. If New York criminalizes more substances than does the federal CSA, the New York statute can't enhance Mr. Minter's sentence, and similarly can't make a non-citizen removable, unless the statute is divisible and we go through this whole complicated controlled substance analysis that is not really applicable in this decision. It's not so applicable, that is, the modified categorical approach, because the issue adjudicated by the district court and the Second Circuit came down to cocaine itself. And the federal CSA also lists cocaine as a federally controlled substance, of course. For years, that might have been the end of the story, and Mr. Minter's criminal sentence would surely be enhanced. Not anymore. Because a variety of circuits, including at least the 7th, 8th, and 11th circuits, have held that state-controlled substances themselves can be different than the federal controlled substance version, even when they have the same name. That is, New York's definition of cocaine is different than the federal government's definition of cocaine. New York therefore criminalizes more substances, technically, than do the feds, even when it comes to cocaine. So the argument goes then, New York cocaine doesn't match the federal definition of any controlled substance offense, and so a possession or sale of cocaine in New York can't enhance a criminal sentence and can't make a non-citizen removable. That is the categorical approach at play if the isomer argument is adopted. The district court in this case agreed. The reason, argued Mr. Minter, and agreed with by the district court, is because, quote, the CSA prohibits possession of only optical and geometric isomers of cocaine, while New York's statute prohibits possession of all cocaine isomers, end quote. That is, under the text of the statutes, the text of the cocaine definitions, a New York cocaine sale conviction could technically occur if a defendant sold some weird type of cocaine isomer that the federal government doesn't criminalize and doesn't care about. Unlikely or not, applying the categorical approach, the text of the statute would make the New York offense broader than the federal definition, meaning that the New York cocaine sale statute can't match the federal definition of a serious drug offense unless cocaine is itself divisible as to which isomer an individual sold, which of course it's not. Meaning again that Mr. Minter wins, as would non-citizens with identical New York offenses if the isomer argument is adopted, which is what the district court did. The government appealed, and the Second Circuit affirmed the district court judge. Because, under the categorical approach, quote, when a state law is facially overbroad, even by a minimal amount, we look no further, end quote. And in what is truly the big holding here, the Second Circuit held that, quote, the proposition applies to the identity of prohibited substances, as the law must criminalize only those substances that are criminalized under federal law, end quote. Now, actually, to dive down a bit deeper, in this case, Mr. Minter's New York offense actually travels under the prohibition in New York of selling a, quote, narcotic drug, end quote. That definition, in turn, includes cocaine. Diving even deeper, New York includes in its definition of cocaine, as we mentioned, isomers of cocaine, without apparent limitation. This is in contrast to the federal government's definition of cocaine, which, quote, defines isomer to mean only any optical or geometric isomer of cocaine, end quote. Emphasis by the court. Kind of like with the antique firearm decisions that we sometimes discuss, the federal government specifically defines what cocaine is and what it's not. New York, like a lot of states, does not specifically limit isomers. It just generally uses the term isomer. What are isomers? We're always talking about them. Well, they are, quote, chemical compounds that have the same composition but differ in the chemical arrangement of their constituents, end quote. That makes them, for categorical approach purposes, different substances, explained the Second Circuit. Restated, as in the 7th, 8th, and 11th Circuits now, controlled substances themselves can be overbroad, like Florida marijuana, Indiana's meth definition at a certain time at least, and a variety of isomer-type things adjudicated recently by the 8th Circuit. And look, I do these isomers decisions often, but rarely does the court explain what they actually are. Not so here, quote, there are two broad types of isomers. Stereoisomers, isomers in which the atoms are joined in the same order but in a different spatial arrangement, and constitutional isomers, which are all other isomers, including what are termed positional isomers, end quote. I wonder if those isomers have a right to privacy. It's a very bad joke, but I'm going to keep it in. And so then, in chemical terms, quote, the CSA includes only stereoisomers, optical and geometric, in its definition of cocaine, but includes certain constitutional isomers in its definition of other drugs, end quote. So the CSA knows how to include more isomers, but doesn't do it when it comes to cocaine. That's an argument applicable to all circuits. New York, in contrast, again, does not limit its criminal code to only optical and geometric isomers. This is in contrast to other drugs like hallucinogens, where New York does limit the isomer type, indicative of New York legislative intent that this whole isomer dichotomy is not just a coincidental mistake. The Second Circuit rejected a variety of very heady counter-arguments put forth by the government, some of which I can only imagine oil will make if and when this cocaine isomer argument is made in another circuit where it hasn't been adopted yet. So check out this decision and be prepared. One of those arguments was, of course, that there isn't a realistic probability that New York will criminalize possession or sale of these weird isomers that are overbroad. But of course, everywhere except the Fifth Circuit, by my reading, the realistic probability test, quote, has no place where, as here, the statute's scope is plain, end quote. But because of that Fifth Circuit anomaly, this decision is pretty much directly in contrast to Fifth Circuit precedent. Also kind of opposed to 11th Circuit precedent, but it's a bit more complicated. End of the story here. Mr. Minter narrowly avoids lots more prison time. Therefore, congratulations Derek A. Cohen and Brian Magic for appellee defendant, and really, for the entire immigration bar. And that is USA v. Minter. Moving on to the BIA, matter of CGT, published by the BIA. This case is about asylum. Mr. CGT is from the Dominican Republic. He testified that he knew he was gay from a young age, and that his father abused and beat him kinda because of this for years. After he left the Dominican Republic and came to the United States, his father began abusing his mother because Mr. CGT was gay. Mr. CGT is now HIV positive. When eventually placed in removal proceedings, Mr. CGT applied for asylum. An immigration judge deemed him credible and found that he was a member of two cognizable particular social groups, homosexual Dominican males and Dominicans who are HIV positive. And yes, the BIA held 33 years ago that homosexual individuals in Cuba are a cognizable particular social group. And based on the BIA's citation here, the BIA believes that that is still generally the case from country to country. The IJ denied relief, though. Not only was the asylum application filed beyond the 1-year deadline, reasoned the immigration judge, but Mr. CGT's membership in those groups wasn't why his father beat him, and he hadn't shown that the Dominican government was unable or unwilling to protect him from harm in the Dominican Republic. And in any event, only his father knew he was gay or HIV positive in the DR. To the BIA, it went, and the BIA sent it back, in part. It affirmed the IJ on the 1-year bar denial. Mr. CGT filed his asylum application well after the 1-year deadline to file asylum applications after entering the US. And although Mr. CGT only got diagnosed with HIV in June 2013, he still didn't file the asylum application until July 2014. So even if that might be a changed circumstance that could make his asylum application timely even though it wasn't timely before, he still then waited 13 months thereafter, and, quote, delays of 1 year or more will be justified in rare cases, end quote. Not a reasonable delay here, which is always a case-by-case analysis. Withholding of removal is still on the table, though. And if Mr. CGT did indeed suffer past persecution all those years ago, then he'd be due withholding unless DHS met its burden to point to specific evidence of materially changed country conditions, or a specific place in the DR where Mr. CGT could safely and reasonably relocate. And on this, the BIA held that the IJ erred. Maybe Mr. CGT's father didn't know for sure that he was gay when he was a child, but he was clearly beating and abusing him because he thought him effeminate, called him a girl, disliked gay people, and indeed suspected that Mr. CGT was gay. More analysis is needed on nexus there on the past persecution, that is, the reasons for the abuse and beatings, and so the BIA sent it back. Still not past persecution, though, unless Mr. CGT can also show that the government in the Dominican Republic was unable or unwilling to protect him all those years ago. But also remember, he was a child at the time. Mr. CGT never reported the harm, but he was a child, and, quote, multiple circuit courts have recognized that due to their young age, children may not be able to articulate their fear or approach law enforcement officials in the same way as an adult, end quote, particularly where the abuser is a family member. The IJ apparently did not consider this, and so must do so on remand. Not gonna lie, kind of makes sense that the IJ wouldn't have adjudicated this issue, because the IJ did deny below on nexus, but that is of no importance anymore. So it's going back for further past persecution analysis. And it's also going back to whether Mr. CGT has a well-founded fear of future persecution, if he ends up ultimately failing on the past persecution inquiry. Because the BIA doesn't love that the IJ seemed to have maybe based this finding of future well-founded fear in part on a belief that only Mr. CGT's father knew that he was gay and HIV positive. Quote, to the extent this conclusion could be viewed as based on an assumption that the respondent could avoid future harm by not engaging in conduct that would identify himself as gay, it would be in error, end quote. To be uber clear for 2023, quote, sexual orientation, like other protected grounds, is a characteristic that either is beyond the power of an individual to change or is so fundamental to individual identity or conscience that it ought not to be required to be changed, end quote. Immigration law doesn't expect anyone to hide it. Great final footnote about engaging in same-sex conduct, too, BIA. Meaning, congratulations David B. Spitzer for respondent and to all people like Mr. CGT. A bit more on just when a government is unable or unwilling to protect an asylum or withholding of removal applicant. Like 3 weeks ago, the BIA provides some standards for us practitioners to use in this decision. For example, a quote, government authorities' timely response to a respondent reporting harm may be indicative of their ability or willingness to protect the respondent from harm, end quote. Okay. Seems like the inverse would be true though too, no? And wouldn't you know it, a quote, failure to report harm is not necessarily fatal to a claim of persecution if the applicant can demonstrate that reporting private abuse to government authorities would have been futile or dangerous, end quote. Not limited to children. That, everyone, is a big quote, if you take anything away from this decision, to be honest. Now, it takes more than simply an applicant's belief that it would be futile to report the harm, and it's a fact-intensive question for an IJ to answer. But then again, detailed credible testimony that explains the basis for a subjective belief of not reporting harm to police is evidence just like anything else. Hope you all listen to the end. And that is matter of CGT. Moving on, we have Ponce-Flores v. Garland, published by the Fourth Circuit on September 6, 2023. This case is about gang-based Convention Against Torture claims. Mr. Ponce-Flores is from Honduras and entered the U.S. without authorization in 2014 at 15 years old. Quote, allegedly fleeing, end quote, MS-13. He'd been in that gang, just absurdly really and to the extent it's even possible, since he was 8 years old. Quote, in the United States, Mr. Ponce-Flores continued to associate with MS-13, was convicted of assault in the second degree, and pled guilty to participation in a criminal gang with a resulting sentence of 10 years in prison, end quote. Horrible case. In prison, MS-13 ordered him to prove his loyalty by killing another inmate. He refused and sought the protection of prison guards, again in the United States. Apparently that didn't work. He then became marked for death by the gang. Quote, MS-13 inmates stabbed him in the head and the neck with broken glass, and he was transferred to another facility for protection, end quote, in the United States. In eventual removal proceedings, Mr. Ponce-Flores applied for cat deferral based on his fear of gangs in Honduras, potentially the only form of relief or protection he was eligible for anyway due to his criminal history. An immigration judge denied in a, quote, thorough opinion, end quote. This despite the IJ believing that the risk that Mr. Ponce-Flores would indeed be tortured or killed by MS-13 or the Mara 18th Street Gang due to his past gang affiliation was, quote, substantial, end quote. The IJ then also held that, quote, corruption within the police force in Honduras exists, end quote, and so that Mr. Ponce-Flores, quote, does face a risk of severe harm with the consent or acquiescence of the government, end quote. These are almost all the CAT elements that a non-citizen must meet to get this protection. But yet, despite these findings, considering the evidence as a whole, including significant efforts to eliminate police corruption in Honduras, the IJ determined that, and this is the IJ now, quote, police would probably meaningfully respond in some form, even if there is a chance that they would not, and even if there is a chance that they would not be successful, to any report of torturous harm or threats against, end quote, Mr. Ponce-Flores. Cat protection requires government acquiescence or consent, not just unable or unwilling like asylum and withholding. So, Mr. Ponce-Flores would be left to his fate, the IJ concluded. The BIA affirmed in a split decision. Lots of supporting evidence and expert testimony presented in this one, it appears. The Fourth Circuit affirmed. Unlike with asylum and withholding of removal, no matter what has happened to a non-citizen in a foreign country in the past, a CAT applicant always, quote, bears the burden to prove that it is more likely than not that he will be tortured if removed, and that this torture will occur at the hands of the government or with the consent or acquiescence of the government, end quote. When conducting this analysis, the IJ and the BIA must consider the aggregate risk of torture from all sources, together, to ascertain whether it is indeed more likely than not that a non-citizen will be tortured with the country's government's acquiescence or consent. In the Fourth Circuit, one way to satisfy this latter requirement, the government action prong, is if a government officer knows of the likelihood of torture beforehand, but, quote, thereafter breaches his or her legal responsibility to intervene to prevent such activity, end quote. That's our legal landscape. And the Fourth Circuit isn't reviewing the IJ and BIA's findings on its own. Its review is largely limited simply to whether the IJ and BIA did something wrong or ignored evidence, for example. Not the case, said the court, because while the record showed corruption in Honduras' police force and involvement with gang activity, it also showed that the Honduran government has taken steps to root out corruption and fired lots of corrupt officers. The IJ weighed all of this and came to a reasonable conclusion regarding what the police would do to protect Mr. Ponce-Flores, reasoned the Fourth Circuit. Nor did the immigration judge err in considering, quote, countrywide reports and statistics in part of her analysis, end quote. Such things are often considered in such cases and even argued by non-citizens in support of their claims sometimes. More importantly here, as the CAT requires, the IJ also considered a litany of factors specific to Mr. Ponce-Flores, including the fact that he's a, quote, MS-13 defector, his tattoos, and the screening process he would likely face as a returning deportee, end quote, in addition to his expert's testimony on these issues. Here, for example, the IJ, quote, considered evidence demonstrating the relatively low number of police misconduct incidents compared to the large number of gang members operating in Honduras, as well as evidence addressing what proportion of Honduran police officers are corrupt or affiliated with gangs. That was not inappropriate, end quote. The Fourth Circuit also did not believe, contrary to Mr. Ponce-Flores, that the IJ and BIA ignored evidence. That much of the evidence supporting Mr. Ponce-Flores' claim was actually discussed in the factual background section of the IJ's decision, and not necessarily the analysis portion, did not warrant reversal. And it seems, anyway, that there were portions of the expert testimony that may have supported denial of CAT deferral, even if, on the whole, the expert probably would have granted CAT deferral if the expert was the judge. And that's often the case, right? At the end of the day, to affirm an IJ or BIA, the court must be satisfied that the agency, quote, reviewed all the applicant's evidence, understood it, and had a cogent, articulable basis for their determination that his evidence was insufficient, end quote. That was the case here. There was certainly enough for a grant, it seems, but a contrary view of the record and denial of CAT protection was not out of bounds or unreasonable. So the Fourth Circuit affirmed, and Mr. Ponce-Flores will likely be removed to Honduras. And that is Ponce-Flores v. Garland. This podcast is sponsored by Journey Business Plans. Journey is the leading business immigration plan writing company in the United States. 10 years. And they know immigration. Heck, they started as an E2 company themselves. Journey prides itself on its responsiveness and overall customer service, preparing business plans for E2, EB2 NIW, L1, EB5, and much more. If you don't yet know about Journey, and don't want to listen to just me, ask your colleagues. Or even better, try them out. Visit www.journey.com and use promo code REVJOURNEY30 for a 30% discount on your first business plan. That's REVJOORNEY30. or click on the link in the show notes. Interested in a case that'll make your head spin? I thought you'd never ask. Next is Velázquez v. Garland, published by the 10th Circuit on September 8th, 2023. This case is about motions to reopen and voluntary departure. Mr. Velázquez is from Mexico and entered the U.S. as a young man in 2005. Placed in removal proceedings years later, albeit with a, quote, deficient, end quote, NTA, he applied for withholding of removal and Convention Against Torture Protection and voluntary departure to Mexico in the alternative. An immigration judge denied everything but voluntary departure, giving Mr. Velázquez 60 days to depart the U.S. The order also advised Mr. Velázquez, as such orders always do, that, quote, were he to judicially challenge the order, the grant of voluntary departure would automatically terminate, and Mr. Velázquez would be removed to Mexico, end quote. Mr. Velázquez appealed the denial to the BIA and lost, but the BIA re-granted him voluntary departure, as the BIA is apt to do. Same warnings, too. Mr. Velázquez did not depart the U.S., and he filed a motion to reopen 2 months after the BIA ruled. See, by this point, all the deficient notice to appear stuff had become much more settled, and I guess Mr. Velázquez had either married a U.S. citizen or had a U.S. citizen child, and because of the deficient NTA, now had the 10 years required to apply for non-LPR cancellation of removal under I&N Section 248B. Because the 10-year clock required of cancellation had never stopped during all these years of removal proceedings because the NTA was deficient, even though there was a removal order. Still hard to get, but generally easier than withholding or cat protection. If only the BIA would reopen and remand this case for an IJ to consider the application. The BIA said it would not. Not only that, but the filing of the motion to reopen in this case terminated the BIA's grant of voluntary departure, meaning that now Mr. Velázquez had a final order of removal and was subject to all the other penalties that such orders bring with them. Which, ironically enough, when a non-citizen fails to depart the United States timely after receiving voluntary departure, includes a bar to receiving non-LPR cancellation of removal for 10 years thereafter. It's actually more complicated than that. We're going to get to it in a second. And so Mr. Velázquez moved the BIA to reconsider its decision, which the BIA denied, and then Mr. Velázquez petitioned the denial of that to the 10th Circuit. The 10th Circuit dismissed the petition for review. Because, see, a main reason for the BIA actually denying the motion to reopen was that the BIA believed it untimely, as that motion to reopen was filed outside the 60 days that the BIA had granted Mr. Velázquez to depart with voluntary departure. The thing is, though, the 60th day fell on a Saturday, and Mr. Velázquez then filed his motion to reopen on that following Monday. With filing deadlines, that's almost always how it works. If an ordered deadline falls on a weekend, the deadline often becomes the next workday. But this wasn't really a filing deadline, the BIA seemed to reason. This was a deadline for Mr. Velázquez to leave the U.S. That he chose to file a motion to reopen is a bit tangential, and doesn't then permit an additional 2-day extension to file that motion just because the date where he had to depart the U.S. fell on a Saturday. The 10th Circuit believed this rationale reasonable. Only the 9th Circuit has ever addressed this issue in a published decision, apparently, and the 9th Circuit disagreed with the BIA's interpretation, meaning that we now have a circuit split between the 9th and 10th Circuits. Reason to the 10th Circuit, quote, regardless of what day of the week a voluntary departure period expires, a non-citizen moving to reopen or reconsider his removal proceedings must file within 60 calendar days from the date the relief is granted, end quote. Because it is true that actually, quote, prior to the expiration of the voluntary departure period, a non-citizen may file a motion to reopen or reconsider, end quote. Such a motion would terminate the grant of voluntary departure and result in a removal order, but would not then come with all the penalties attendant to overstaying voluntary departure, apparently, as occurred here, and which includes preclusion from even applying for non-LPR cancellation of removal for 10 years. And of course, even if it then all results in a removal order, that removal order could be reopened, should the BIA so choose. Not only that, but, quote, if the respondent leaves the United States within 30 days upon filing a motion, He is deemed to have departed voluntarily, end quote. Complicated framework. But none of that applies if, like here, the motion to reopen isn't filed within the voluntary departure period, which here was 60 days. Confusing, right? And really on all of this, read the regulations because it's very confusing and very impactful. Anyway, the 10th Circuit agreed here that the 60 days expired on that Saturday and didn't roll over to that following Monday. This is so even though EOIR official policy is that, quote, when a deadline falls on a weekend or legal holiday, it is construed to fall on the immediately following business day, end quote. So yes, filing deadlines ordered by the court appear to be automatically extended, but not so with deadlines to depart the U.S. But the deadline to file a motion to reopen in the voluntary departure context is tethered directly to the deadline to depart. The 10th Circuit believes that that is the framework that governs, not the framework for filing deadlines per se. Because the maximum voluntary departure deadline, after all, is statutorily limited to 60 days. So it doesn't make sense to the 10th Circuit to permit EOIR policy on filing deadlines to extend that deadline, even by a few days. Plus, reasoned the 10th Circuit, a non-citizen could file a motion to reopen and then voluntarily depart the U.S. within the deadline. Those two things aren't mutually exclusive and apparently wouldn't result in a per se denial of the motion to reopen. As I mentioned, the Ninth Circuit held otherwise in Meza Vallejos v. Holder from 2012, believing that the effect of the rule adopted by the BIA in unpublished decisions, and now the 10th Circuit precedentially, quote, was to unfairly shorten the statutory departure window, end quote. The 10th Circuit believes the 9th Circuit's reasoning, quote, creative, end quote, and an improper extension of the clear statutory 60-day maximum limit on voluntary departure. Mr. Velázquez, therefore, did not succeed. And one more thing. In this decision, the 10th Circuit also denied Oil's attempt to extend Patel. Oil argued, as it's been doing, that because Patel divests circuits from the authority of reviewing the substance of the denial of voluntary departure, should voluntary departure itself be challenged on direct petition for review, that a court can't then review the denial of a motion to reopen or reconsider where the underlying issue involves voluntary departure. Quote, we cannot agree, end quote, explained the 10th Circuit. Quote, this theory misconstrues the issue and overstates the implications of Patel, end quote. Indeed. Give this decision a read when you have similar issues in the 10th Circuit or in any other circuit that hasn't yet addressed this very heady issue. And that is Velázquez v. Garland. Next up is Martinez-De Umana v. Garland, published by the 5th Circuit on September 8, 2023. This case is about asylum. Ms. Martinez-De Umana and her two daughters are asylum seekers from El Salvador. Ms. Martinez-Umana, as the lead applicant, claimed in immigration court proceedings that she worked for El Salvador's Ministry of Justice from 2012 to 2014, the ministry that oversees El Salvador's prisons. She worked as both a security officer and as administrative staff later. One day, while in uniform and on a lunch break, a neighbor affiliated with MS-13 saw her and mentioned how he didn't know she worked for the ministry. After that, she began getting contacted by various MS-13 members, and they started to monitor her house. She was scared and took a 2-month leave. Then in May 2014, 2 of her co-workers were killed by gang members on a bus. She and her daughter left El Salvador a few days later. The gangs then began attacking her husband. MS-13 wanted to know where Miss Martinez-De Umana was. They attacked him brutally 4 times and even shot him. He is still alive. Miss Martinez-De Umana presented the expert testimony of Dr. Thomas Borman, a known expert in the asylum world and not the first time that Dr. Borman has appeared on the podcast. Dr. Borman's testimony supported Miss Martinez-De Umana's claim. And IJ denied for pretty much every reason except credibility. The BIA affirmed by split decision. Only asylum and withholding of removal are before the 5th Circuit. The 5th Circuit affirmed the BIA. The matter really came down to 2 issues. The first, matter of Fuentes. That old BIA decision considered the asylum claim of a former gang member of the National Police of El Salvador. It's an old case, so rather than a fear of gangs, the applicant feared guerrilla insurgents. Importantly here, the BIA reasoned in that decision that policing is inherently dangerous, and the, quote, dangers faced by policemen as a result of that status alone are not ones faced on account of a protected ground, end quote. The Fifth Circuit has then applied the Fuentes rationale before in similar contexts. The IJ and the BIA appear to have relied heavily on Fuentes to deny the cognizability of Ms. Martinez-De Umana's particular social group based on her work for the Ministry of Justice. Ms. Martinez-De Umana argued that in doing so, the agency impermissibly imposed a per se rule, rendering foreign government employees ineligible for asylum instead of conducting the necessary case-specific analysis. A smart appellate argument. The Fifth Circuit was, quote, unpersuaded, end quote. Essentially, the Fifth Circuit believes that, like the non-citizen in Fuentes, Ms. Martinez-De Umana assumed the risk when she went to go work for El Salvador's Ministry of Justice. Matter of Fuentes did apply to her, and it looks like the Fifth Circuit doesn't really believe much more analysis is required. Ms. Martinez-De Umana's particular social group, based on her employment for the Ministry of Justice, does not serve as a sufficient basis for a nexus to the harm that she fears in El Salvador. Nor did the court believe that her fears were based on an imputed anti-gang political opinion. Quote, the record reflects that the primary reason the gang members targeted Ms. Martinez-De Umana was to exploit her work-related access and knowledge from her employment with the Ministry of Justice in order to further their criminal enterprise, end quote. Finally, the Fifth Circuit did not believe, as Ms. Martinez-De Umana argued, that the IJ disregarded Dr. Borman's testimony. Now, it does seem that the IJ did find Dr. Borman credible and did certify him as an expert. It seems. But under BIA precedent published in 2020, just because an expert is certified doesn't mean that an IJ, quote, must accept all the testimony and opinions provided as facts, end quote. The Fifth Circuit believed that the IJ sufficiently considered the testimony of Dr. Borman because the IJ summarized it and said that it had been considered. Don't get me wrong, I do recall that an IJ must explain why they are rejecting such testimony by relying on record evidence, and cannot just cast expert testimony aside. That's my recollection of matter of MAMZ and matter of JGT. But that is undiscussed in this decision. Episodes 34 and 22, if you're interested. All of this means that Ms. Martinez-De Umana did not succeed, and that her and her daughters are subject to removal to El Salvador. And that is Martinez-De Umana v. Garland. Hope you saved your thinking caps to the end, because we have Alonso Juarez v. Garland, published by the Ninth Circuit on September 8th, 2023. This is an outrageously complicated decision about jurisdiction and reasonable fear review. It's the next in a rapidly progressing line of cases addressing this issue. The Ninth Circuit has stepped in and issued a ruling favorable to non-citizens. Let's go. It's a long decision, authored by the Chief Judge of the Ninth Circuit, and it's on an issue oft discussed of late, so I'm not going to dive too deep into all the winding facts in law, if I can pull it off. But suffice it to say, Mr. Alonso Juarez is from Mexico, and has pretty much lived in the United States for 25 years. He's been removed once and then entered without authorization after that, remaining in the U.S. undetected for many years. The issue is this. What happens when a non-citizen is ordered removed, is physically removed, re-enters without authorization, has that first removal order reinstated, and then claims a fear of persecution or torture? Well, he gets a reasonable fear interview. We all know that. In some cases of late, though, the asylum officer has determined that the non-citizen has a reasonable fear. The non-citizen is then placed in withholding-only proceedings, has withholding and CAT denied by the IJ and the BIA, and then seeks circuit review. In other cases, like here, the asylum officer doesn't even find that the non-citizen has a reasonable fear of persecution or torture. The non-citizen then appeals that no reasonable fear determination to the immigration judge, and then, in most if not all circuits, has the right of directly petitioning for review to the circuit courts of appeals. Hope you're still with me, just getting started. The problem now is that OIL has been arguing that in both of those types of situations, the only final order of removal that a circuit can review is the old removal order that got reinstated. The Supreme Court's recent Nasrallah and then Guzman-Chavez decisions have held that withholding of removal and cat protection are a bit separate from an actual removal order itself. Meaning, Oyl argues in an effort to extend the rationale and cut off judicial review, that non-citizens can't actually get review of reasonable fear denials or denial of withholding of removal or cat protection in withholding-only proceedings. The reason is because the statute tethers circuit review to the review of final orders of removal, and the deadline to get that review is 30 days post-order. Or at a minimum, sometimes, post-reinstatement. But the reasonable fear process, and certainly full withholding of removal proceedings, post-reinstatement, will never occur within 30 days. Ipso facto, all or nearly all withholding of removal and Convention Against Torture seekers who lose following reinstatement, or who are deemed to not even have a reasonable fear of persecution or torture, can't get circuit review of the agency's denial. A bar that is found nowhere in the statute. The Second Circuit and Bhaktabhai Patel, and then the Fifth Circuit, have agreed. The Third Circuit too, apparently, in an unpublished decision, so watch out. The Tenth Circuit rejected the argument a few weeks ago, as did the Sixth Circuit in an unpublished decision. And now, the Ninth Circuit has rejected it too. Totes going to the Supreme Court soon. What this means in the Ninth Circuit is that things are like they always were. Under circumstances like this, a quote, petition for review filed within 30 days of the conclusion of reasonable fear proceedings is timely, end quote. Mr. Alonso Juarez did that. He petitioned for review to the Ninth Circuit 30 days after the IJ affirmed the asylum officer's no reasonable fear finding. Such challenges bypass the BIA, so his petition is timely. The reason, that is, the reason it's timely and that Nasrallah and Guzman-Chavez don't change it, is because to the Ninth Circuit, the finality of a removal order, including a reinstated removal order, is governed by INA Section 11A47. That statute states that removal orders become final, quote, upon the earlier of 1, a determination by the BIA affirming such order, or 2, the expiration of the period in which the non-citizen is permitted to seek review of such order by the BIA, end quote. But the statute isn't clear on what happens when a removal order is reinstated and a non-citizen is seeking to have it withheld or deferred due to a fear of persecution or torture. And it's ambiguous because with a reinstated order where an asylum officer makes a no reasonable fear finding, there is no way to appeal the order, that is the no reasonable fear finding, to the BIA. Such a framework to the Ninth Circuit, complete unfettered decision-making by an asylum officer and an immigration judge without any appellate review, quote, could raise serious constitutional concerns, as the suspension clause of the U.S. Constitution unquestionably requires some judicial intervention in deportation cases, end quote. Rarely do administrative agencies get the last word in the United States, and immigration law is, and should be, no different. Reason of the court, relying on the U.S. Constitution. That's what the Ninth Circuit has said previously, and all of those concerns remain. Heck, Oyl used to kind of share them, as did nearly all circuits. That is, until the Second Circuit in Bhaktabhai Patel, quote, unilaterally departed from it, despite the petitioners and the government's insistence that the court had jurisdiction, end quote. Nasrallah and Guzman-Chavez don't, of course, take away these constitutional concerns. Also, importantly, neither decision had anything close to do with the legal question at issue here. Oyl is arguing to extend the logic of those decisions. In Nasrallah, the Supreme Court had review over the final order of removal already. All the stuff about Convention Against Torture being separate was just about whether circuits can review factual questions once they already have authority to review. Very different context, materially so, as the non-citizen is still getting review. It's just how. The dispute here, in contrast, would wipe out review entirely. As to Guzman-Chavez, that case was all about release from immigration detention and truly had nothing to do with this dispute. And the Supreme Court expressly cabined its decision anyway. As to Judge Menashe's decision in Bhaktabhai Patel, well, the Ninth Circuit seems a bit shocked about the court being okay with what is essentially, quote, wholesale elimination of judicial review of virtually all withholding-only decisions, end quote. In conclusion, the old framework stands in the Ninth Circuit. If that wasn't complicated enough, there are actually two more holdings in this decision by the Ninth. The first is that, following the Supreme Court's decision in Santos Zacharia, that whole 30-day rule for petitioning for review final orders of removal isn't even jurisdictional. That rule is INA Section 242b1. Instead, like seemingly everything else now, including exhaustion of issues pre-petition for review, the 30-day rule to petition is a claims processing rule. That probably means that 30 days is subject to equitable tolling where circumstances warrant, but that issue wasn't actually decided by the Ninth here. Finally, the Ninth Circuit rejected Mr. Alonso Juarez's argument that the reasonable fear screening regulations are inconsistent with the statute for withholding of removal. Mr. Alonso Juarez very intelligently argues that because withholding of removal is technically mandatory, if the elements are met, and that the substance of withholding of removal requires an IJ to make fact-intensive credibility determinations, a limited pre-screening process not even by an immigration judge makes no sense and undermines the statutory framework implemented by Congress. It is pretty dang complicated, but in essence, the Ninth Circuit said that the statute is ambiguous at best, and that DHS and DOJ's reasonable fear screening and review framework in the regulations is reasonable. So unless and until Chevron deference goes away, the reasonable fear screening process is okay. Mr. Alonso Juarez did not succeed on the merits of his claim, addressed in an unpublished order that I believe was issued the same day as this decision. But on this important jurisdiction ruling, not to mention the whole claims processing rule thing, congratulations to Vicky Dobrin and Hillary Hahn for petitioner, as well as Kristen McLeod-Ball and Trina Relmoto from the National Immigration Litigation Alliance on amicus, as well as a whole bunch of ACLU power hitters. Woof. And on a Friday to boot. And that is Alonso Juarez v. Garland. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli & Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook at Immigration Review, or send us a tweet at ImReview, that's IMM Review. I'll be back next Monday for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.